7 and 76A.
Yes.
And the important thing for the purpose of this particular line of argument is the provisions of power under section 425, where it sets out a menu of options.
Yes.
One of which, D, is to require any person to pay to any other person in respect of benefits received from the debtor such sum as the court may direct. But it's just again one of a menu of options. Can I take you back to paragraph 100 of the judgment?
Paragraph
100 on page 755.
Yes.
Under heading issues of law.
Yeah.
Then at 101 she deals with section 423 and the question of victims. At 756, letters A to B, she says, 4 lines down, what subsection 3 requires the purpose should be one which is to prejudice the interests of a claimant or prospective claimant, the interest of a person or wider his rights, the expression of interest of a member in section 459 of the Companies Act 1985, rights of members of the company to apply for relief against unfair prejudice have been similarly construed. At 105, she sets out, refers to the fact that section 425 sets out a non-exhaustive list of the orders that may be made, and then says 1986 does not specify any period of limitation in relation to a claim under section 43, although section 43 has been in the statute in one form or another since 1571. There's no reported case that we've seen which decides whether any period of limitation applies to claims under the section to know what that period is. But at 106, she turns to the question of the limitation issue.
Yeah.
Is there a statutory period of limitation for claims under section 43? And if the answer is yes, when did the period of limitation begin to run? The proceedings began on 4th December 2002, over 12 years after the settlement was executed. Therefore, the action must fail unless there's no period of limitation over a period of 6 or 12 years and began with a period of 6 or 12 years ending on the 4th of December 2002. That would be the case if the period begins on the date of the bankruptcy order. Then at 108 sets out the relevant statutory provisions, section 8 and section 9. And at 110, we were shown no authority which decides its limitation point. In a recent case of law cited in Southall, this court proceeded on the basis there was no applicable limitation period. That case concerned gifts made by the debtor, and it may be that the parties took the view that if there were any statutory period, its commencement would be postponed under section 32 of the 1980 Act. In the present case, the judge held that there was an applicable limitation period and considered the claim was a specialty. However, he held that the limitation period 12 years ran from the date of the bankruptcy order, so the claim was brought in time. He then addresses questions of issues, and then at 115 turns to the question, is there a statutory period of limitation?
Yeah.
Can I invite you to read 115, 116 and 117, please?
Is the reason that the statute barred debt cannot be proved in bankruptcy because bankruptcy is a proceeding in a court of law, and you can't, and the Limitation Act says you can't found an action on a contract in a court of law after 6 years? Is that the reason, or is there some other reason?
My Lord, can I think about that and come back to you, because I'm not sure.
Can I make a suggestion then, which you might also want to think about? Winding up and bankruptcies are collective remedies on behalf of the general body of creditors who can prove their debts in the resultant insolvency. And if you have a statute barred debt, you can't prove it in the insolvency. Therefore, you can't invoke the collective process.
Yeah, your Lordship's right about that. That may be the answer to the question. I'm not sure whether that was actually an answer to.
I don't know whether. I throw it out. I mean, I think I'd always understood that you can't petition on the basis of a statute barred debt because you wouldn't be able to prove it in the insolvency, and therefore you can't invoke the collective process of winding up or bankruptcy on behalf of a body of creditors of whom you are not one.
Not one. Well, not one who can prove. Yes.
And that I've always understood. And I may be wrong in that, but that's what I thought. What I actually wondering was whether actually a petition to the court for winding up or to commence bankruptcy proceeding was an action on anything within the meaning of the Limitation Act.
The answer to that is in section 38 of the Limitation Act, which provides
Any proceeding in a court of law?
any proceeding in court. Yes.
So it must be the former explanation, I suspect.
Yeah. So does that answer? I haven't answered your question, my Lord, but does His Lordship's question answer your question?
Yes.
Thank you. So sorry.
That's down to 117.
Yeah. And then she effectively concludes at 118 as the application of statutory limitation period is consistent with the decision of this court and Farmers are also consistent with Mr. Randall's decision. And then you say, as we've not heard argument of formal relief in respect to the settlement, I would leave open the question whether section 9.1 could apply to that part of the trustee's application in that respect.
Which part?
The relief in respect to the settlement was to get have a compendium order that puts the HMRC in the position that they would have been and had the tax been paid at the time. So whether or not that was a money order or not. So we've provided the extracts from the Cork report in the clip we've handed up. But again, it's the same point as we make in respect to the Law Commission. The fact that the Cork report, a very important command paper, said there was no limitation period did not stop the Court of Appeal saying actually there is a limitation period. Because like in the Law Commission paper, they don't cite any authority for that proposition. So now, at 119 to 129, she deals with the question of when the limitation period began. That's not relevant for these purposes, so we can skip over that. Sir Martin Norse's judgment starts at page 765. And he agrees with everything apart from the limitation issue, paragraphs 106 to 119. You'll see how he deals with Law Society and Southall as 141. Parties and thus the court proceeding on the basis there was no period of limitation applicable to the claim. What is clear on the point was not argued, so that decision has no assistance in the present case. Then he sets out at 143 to 144, no general rule and action brought by a trust in banks is not subject to provisions of the Limitation Act. I see no justification for to be an exception in the case of a claim brought under section 423. Confirmed by such authorities may be said to bear on the point, in particular in prior garage. The second question is whether the claims of the trustee in bankruptcy covered in section 8.1 or section 9.1 of the Limitation Act. My own view, like that of Judge Weeks, is that since the main claim was an origin and substance of claim to set aside the settlement, the action as a whole was an action upon a specialty within section 8.1. Because the action was commenced on 4th December 2002, more than 12 years after the settlement was made, and less than 6 years after the bankruptcy order was made, the question whether the applicable period of limitation of 12 years or 6 years is academic.
Just explain that.
Because if it had been 12 years from the date of the settlement, it would have been, sorry, the date of the settlement was more than 12 years before the action begun. So even if it was 12 years, it would have been statute barred. But because the claim was brought within 6 years of the bankruptcy order, then it didn't matter whether it's 6 or 12 years, because he went on to hold that time begins to run from the date of the bankruptcy order.
I see.
So it was academic in that case, which whether it's 12 or 6 years, if it started with the making of the bankruptcy order, then it was within time. If it started with the date of the settlement, it was out of time. So that's why he says it's academic.
We don't need to be bothered about this. When did time start to run? Of which
Absolutely not, no.
I find that area of the case quite difficult.
Yes, but what is clear is that although he disagrees with Lady Justice Arnold that it was the date of the settlement,
He agreed with the basic proposition.
he agreed with it's Section 8 or Section 9. So one, there's a limitation period, two, it's Section 8 or Section 9, depends upon the relief that is being sought. So I don't think we need to read the bit about when it starts. And then Lord Justice Waller, 152, agreed with Lady Justice Arden, apart from limitation, agreed with Sir Martin Norse on that. So all three were agreed there is a limitation period. All three are agreed it's either under Section 8 or Section 9.1. The majority saw there being no difficulty with being differing limitation periods for different applicants under Section 423. And so we say, applying the principles from the three cases together, we say the fact that the Law Commission said no limitation period is neither here nor there, just the court report got it wrong, so we say that the limitation, so did the Law Commission. There is a limitation period which is either under Section 8, for 12 years is an action of specialty, or if money is sought under Section 9.1. And to establish that, you look at the relief claimed. In this case, it's expressly money, so you don't need to go any further than that. If it's not expressly money, you adopt the look and see approach and say what is actually the true substance of what's being sought. And if the true substance is money, then it's 6 years. And therefore we say the claim here is subject to a 6-year limitation period, and the Vice-Chancellor was wrong to hold it was not. In our learned friend's supplemental skeleton argument, they've raised an argument based on Smith and RBS, which basically says that until the court has determined there has been unfair prejudice, there's no cause of action. That is plainly wrong, because you don't need...
What is the argument or Smith? We can't say Smith is...
No. The argument is plainly wrong. No, Smith is a very particular decision on Section 140A and 140B of the Consumer Credit Act.
During a continuing relationship.
During continuation. And the question is whether the relationship is unfair as opposed to whether there has been unfairly prejudicial conduct. So we're not looking at the same thing at all. So you need stage one that is an unfair relationship, and therefore limitation then begins to run from that. Well, during continuing relationship, once the relationship's ended, it's 6 years from the end of the relationship. And it's just a wrong argument. I don't know how much detail I need to go into and dealing this, and whether I deal with in reply if it's pressed. But the cases relied upon about giving relief, when it says the court has no jurisdiction, precision bellows, etc. The court has no jurisdiction to grant relief until unfair prejudice has been found. Yes, that's right. But the court has no power to make an order for damages until a contract has been found to have been breached and loss has been found to have been suffered. It doesn't mean the cause of action starts only when the court makes the determination that there has been a breach of contract. So it simply doesn't assist them. And those cases are all cases which deal with effectively the power of the court to grant interim relief. I'm not going to agree that I've had unfairly prejudicial conduct. I'm very happy to buy your shares at a market value. Please, court, will you set out a mechanism? The court says, no, I can't. Sorry.
So I was going to ask you, on that point, presumably you say that it would be perverse if if the cause of action doesn't accrue until an order is made. Is that the argument?
That's the argument that's being run, yes. So there would only be a limitation period starting following the trial, which is absurd.
Just going.
Or you would say this is an abusive process because you haven't got a cause of action.
There is no case. Strike out. There's no cause of action. Yes. You could never bring a 994 petition because the court would never have jurisdiction to
You
entertain it.
stick with the definition of cause of action in the tag of Cooper, namely a set of facts which entitle you to believe the difficulty doesn't arise.
So I don't intend to address the response to that in any further detail unless.
Just on the second point, just what something you said, I think, in relation to 423, and it may not matter, and if it doesn't, we'll move on. I think you said it doesn't matter that there may be different limitation periods, or at least the Court of Appeal appear not to have been bothered by the fact that there might be different limitation periods for different applicants.
The only reason I say that is because in the response to an argument, they say that our arguments lead to conclusion you could have different limitation periods depending on what relief you were seeking.
Right, but that's a different point. Because the slight problem one of the problems I have with the idea that you could have different limitation periods for different people in relation to the same transaction under section 423 is that an application for an order under 423 is made on behalf of all victims of the transaction.
Well, that was addressed at length. I haven't been through those parts.
That doesn't matter for our case.
That doesn't matter, no, but the principle is it doesn't, the Court of Appeal has previously said the fact that the same set of facts can give rise to different limitation periods, depending upon the relief which is being sought, doesn't mean you can't have different limitation periods.
That's a different way where you've got the same person seeking different remedies, some of which may be statute barred. I understand that.
Yep.
But that's, so, fine, okay, so there's nothing turns on that aspect of section 423.
No.
Right.
Well, I mean, a very common example is an allegation of professional malpractice, which you can either frame as breach of an implied term of the contract or breach of a common law duty in tort, and causes of action accrue at different times.
But you don't tend to get a different limitation period.
No, that's because the statute is 6 years for each.
That's right.
But the causes of action accrue at different times.
Can I then, so that's the end of ground 3, save, we say it applies directly. If it applies by analogy, we've addressed that at paragraph 37.
The analogy applies only if what is being sought is equitable relief.
Effectively, yes. So that's why I was...
It's not an injunction, it's not specific performance, it's either other equitable relief or you don't need to get into section 36.
That's right, yes. So we set it out in the context of section 21, but it applies equally to section 9.
Well, it applies with
Sorry,
more force to section 8 and 9 because they are amongst the specified limitation periods in section 36, whereas section 21 is not one of those periods.
So I meant to say my submissions apply equally to section 9 as they do.
Are you abandoning section 21?
No, I'm going to do that very quickly, if I may. Can I just... I don't want to amplify anything we've said in paragraphs 37 through to 56. So to invite you to note a paragraph 54, the quote I've given from the...
Hang on a minute. You want us to go to paragraph
54 of our skeleton argument.
Yes.
We quote a passage there from Lord Justice Clerk in this court. The reference in the bundles, for your notes, is tab 10 of the authorities bundle at page 279.
Yeah.
And you can see what he says there. And as we say, the relief sought here is monetary compensation of exactly the sort that Lord Justice Clerk was talking about. There, you assess it the same way as you would at common law with a but-for causation test.
Yeah.
And the fact they've added the word equitable into their prayer for relief doesn't make that different. As Lord Justice then rightly pointed out, it should have just been compensation, as per Lord Justice David Richards. Ground 2A, my Lord, we say that if Section 9 doesn't apply, and if Section 21 doesn't apply, then by analogy, we would be sections 2 or 5. In reliance to that passage in the Sierra Imperio case I've just taken to, we say that this falls within section 2 or 5 by analogy. So if we're not in section 9, we're going to section 2 or 5 by analogy. I think I can just deal with that very shortly. We've filed a supplemental skeleton.
Sorry, let me just look at the grounds of appeal again. Because I had understood you were wanting to apply section 21 by analogy.
And section 2 in our amended grounds of appeal. Actually, in the core final.
Yes, I see. Yeah.
Thank you. So section 21, if I can deal with that relatively briefly, my lords. First subsea is a very difficult case, and one which I've spent days writing notes about it, but I don't have days to go through them with your lordships. Zedra says section 21, so perhaps I take you to section 21 to begin with itself, just to remind you what it says, which is in tab 42, page 1439. So Zedra says section 21 is not in play because the company, THG, is the beneficiary of the trust for all purposes. And therefore it says section 21 can't apply because it's not an action by THG. And if that's right, then one goes to ground 2A. So if it's not 21, it has to go under 2 or 5, so it doesn't assist them. They've sought to argue in their Respondent skeleton argument that if this claim falls within section 21 at all, that as there are allegations of bad faith against the directors, although no particulars are given as to what directors said to have done what, this claim falls within section 21(1)(a), the Limitation Act, so we can't rely on section 21(3) because of first subsea. We, in our submission, say that first subsea represents a wrong turn, and if it can't be distinguished here, you're bound by it, and we have to go to the Supreme Court to try and argue that that's wrong. We say in our skeleton that in fact, paragraph 34, that the complaint is based on alleged breaches of the allotment duty and the capitalisation duty by the then directors. Those are duties owed to the company. If the company breached its duty to its shareholders under section 630, the remedy would be for the company for Zedra to sue the company for a declaration that the allotment was not valid and the changes to the articles have been invalid. If they'd done that, the company would then have an immediate claim over against the directors who caused the company to do that, and that would be the loss that it had to pay out to Zedra. So we say it does fall within, it can fall within section 21. They say no loss has been suffered by THG, therefore it can't fall within section 21. But it doesn't have to be. You don't have to have a claim for loss. You could have an example where you wanted to get a declaration that a particular director had breached his duties and therefore you're entitled to get rid of him to make him a bad leaver under provisions from in the Articles of Association saying bad leavers get paid less. That would not itself involve a loss to the beneficiary, but it would still be an action which could fall within section 21. It would have to be brought within 6 years. So we say you don't actually need to have a loss, but if you do need to have a loss, there's potential loss to the company because of the company's right to claim over against the directors. Now, in their respondents' notice, they seek to uphold the judgment on the basis of there being allegations of bad faith, which I took your lordships to earlier on, and that says so that basically that means it goes into section 21(1)(a), relying upon first subsidy. We say that argument cannot work because bad faith, assuming bad faith, as put in this case, can amount to fraud for the purpose of section 21(1). For first subsidy to be engaged in respect of a claim for breach of a duty owed by a director of the company, the bad faith must be bad faith by the director towards the company. Or the fraud must be on the company. But the only plea is the directors acted in bad faith towards Mr. Nobahar Cookson. That's what section 45F is all about. So it's not bad faith vis-a-vis the company, or fraud vis-a-vis the company, but so we've got allegations of breach owed to THG, but bad faith as against Mr. Nobahar Cookson and Zedra. So we say those are ships passing the night, but effectively they don't get into 21(1)(a) because there's no allegations of bad faith by these directors towards the company. So it simply doesn't work. And their supplemental skeleton argument, paragraph 3, simply fails to distinguish between the company and Zedra in terms of the bad faith that's alleged. So we say there's no relevant fraud which could disapply section 21(3). My lords, first subsidy itself, what did first subsidy decide? It decided that a director who breached his fiduciary duties and had benefited personally as a result of it was caught by section 21(1)(a), where he had been guilty of fraud or dishonesty. What it did not decide is that a director who has received no benefit at all, personal benefit at all, falls within section 21(1)(a). First subsidy itself, my lords, is at tab 16. Can I invite you to look at in paragraphs 2 and 3 at 615 to 616, it sets out that the judge held Mr. Emmett, the director of first subsidy, he was liable to account in his order to pay damages for conspiracy to injure by unlawful means. The issues they had to decide are at paragraph 4, whether the relevant claims against Mr. Emmett were an action to recover trust property in respect to any breach of trust under section 21(3), and if so, whether the judge is entitled to find the breaches of trust were fraudulent within the meaning of section 21(1)(a). Alternatively, paragraph 2 of the order relates to claims to recover trust property, and if not within section 21, whether any limitation period applies to claims or any of them by analogy under the provisions of section 36 of the 1980 Act. At paragraph 21, on page 619, he cites a passage from Foster Bryant, Surveying and Bryant about the obligation of the director to act towards it with loyalty, good faith and avoidance of conflict of duty and self-interest. And then sets out principles there which don't we need to go about, look at in any great detail, but it's on paragraph 9 of the quote. It says the underlying basis of the liability of a director who exploits after his resignation maturing business opportunity of the company is that this opportunity is to be treated as if it were the property of the company in relation to which the director had fiduciary duties. By seeking to exploit the opportunity after resignation, he's appropriated himself that property. It's just as accounted as the trustee retires without properly accounting for trust property. Paragraph 25, he sets out the findings, at page 61, the findings of Mr. Justice Norris at first instance, which essentially were that his preparation and submission of bids for 3 contracts were in breach of his obligations to the company because he was the director of them. We turn to limitation at paragraph 28 and recognises that, it's at bottom 622, in order to avoid the claims of breach of fiduciary duty being treated as statute barred by analogy to claims in contract or tort, BSW accepted had either to bring the claims within section 21 of the Act or to be able to rely on the postponement of the commencement of the limitation period under 32(1)(b). So it doesn't go within 21, then by analogy it was statute barred. Now, well, what underlines the rest of the judgment, I'm not going to have time to take you through it in detail, but what underlines the rest of the judgment is the question of what duties a director owes in respect of company property and otherwise. So cases such as J.J. Harrison, which is cited, Bungin and Fielding, which is cited, all talk about a company director having trustee-like duties in relation to property of the company. So that's what the law was understood to be, that where a director, for example, disposes of company property in breach of duty, he is liable for that because he has breached his trustee duties in relation to property of the company. Now, in this case, they held that the money that had been made wasn't actually property of the company, but he was accountable for it as a constructive trustee by virtue of it having been obtained, a benefit having been obtained by him as a result of his breach of fiduciary duty. So we say, as far as the case needs to go, and the repeated references to it in the analysis of the judgment, is they're looking at it's wrong to equate a company director to a trustee for all purposes. The company director has trustee-like duties for when dealing with the company's property. Now that, we say, is not the case here. There's no question here of us, the directors here, dealing with the company's property. That's as far as the case needed to go in order to decide there. It's right at 62 and 63 of the judgment, paragraph 62 and 63. He doesn't, Lord Justice Patton does not limit himself in those terms. I invite you to read this before ruling on this, that in 58 and 59, he's talking about the liability of a director to account for the benefits he's received. And he does go wider in 62 and 63. But we say that's obitur because it clearly wasn't necessary for the purposes of that judgment. And we say you're not bound by it and it's wrong. My lords, I've gambled to that very swiftly because I wish to leave Mr. McCourt for some time to deal with ground 4. But on grounds 1, 2, 2A and 3, unless there's any further I can assist you with, my lords, those are our submissions.
Thank you very much.
My lords, I recognise that I'm already in injury time.
Yeah.
But as you will no doubt have appreciated, if you're against us on all of grounds 2, 2A and 3, ground 4 can't rescue the appeal.
Yes.
So I'm going to make my submissions on the assumed basis that you find that the 2016 complaint is subject to a limitation period. And I won't keep repeating that assumption. Ground 4 can't save the appeal, but if you are with us on one of the limitation period points Mr. Ashworth has elaborated, nor can success on ground 4 rescue the appeal for the respondent. Because if the July 2016 complaint and the claim in respect of it is time barred, the absence of any applicable rules governing the circumstances in which it can be introduced by way of amendment is nothing to the point. The claim is time barred and so has no real prospect of success, and permission to amend ought to have been refused on that basis. So it is only if you are with us that on one of the other grounds that this question arises for determination. The ground concerns the Vice-Chancellor's ruling that Section 35 and CPR 17 are not applicable to unfair prejudice proceedings. That ruling was, to borrow the language of Lord Justice Nugee in Satyam Enterprises, the judge's own idea, which had formed no part of either party's case. The point was not canvassed by either party. The Vice-Chancellor invited no oral submissions on it, nor did he raise it in the hearing. In the circumstances, it was not open to the Vice-Chancellor to rule on the point. It was, with respect to him, an impermissible ruling for him to have made. In view of the time, I won't take your lordships to it, but in support of those submissions on impermissibility, I rely in particular on paragraphs 36 to 38 of Satyam.
Well, that concerned the theory of the facts which the judge invented.
It does, but I mean, my lord, the shortcut through this is we should decide whether you should decide whether the judge is right or wrong. But it's a point that wasn't canvassed, and therefore there was no argument on it.
Yeah, well, we've got the chance now.
I've got the chance now, exactly. So I'll move on to taking that chance, my lord. The Vice-Chancellor's very limited reasoning on the point is at paragraphs 108 and 109 of his judgment. So I was looking at it in Core Bundle tab 7 at page 107.
Yeah.
And my lords, we say with respect to the Vice-Chancellor that his reasoning, narrow as it is, or limited as it is, does not bear scrutiny. To understand why that is, one must go to section 35 of the Limitation Act. And my lords are all working from hard copy, I understand, so my page references unhelpfully are the electronic bundle. But if you're able to turn to section 35 at page 1459 of the Choice Bundle, I'll give you tab 42. I'm very grateful to Mr. Ashworth. If my lords have that in front of them, the first important point to note is that if we are right that the claim in respect of the July 2016 complaint is time barred, then Zedra needs the complaint to come within the Section 35 scheme in order for relation back to work.
Well, there's an anterior stage, isn't there? You say that the unfair prejudice petition is an action on a specialty,
Yes.
under Section 8. And since it is an action to recover any sum recoverable by virtue of an enactment, it is in fact an action for which a shorter time limit is prescribed by Section 9.
Yes.
It follows from your argument that a petition alleging unfair prejudice is an action as defined by Section 38,
Yes.
which includes any proceeding in a court of law.
Yes.
Now, the Vice-Chancellor's first step in his reasoning is that Section 35 does not accommodate a claim for relief in an unfair prejudice position where it couldn't have been brought in a claim form. Now, I think implicit in that reasoning is that it's not an action at all.
No. Well, I see why my lord considers it to be logically anterior. I was going to come to it after 35, but I'll deal with it now.
If it's not an action,
Then we're not in that territory.
then we're not in Section 35 at all.
Then we're not in 35, and then there's no relation back, my lord.
Yeah.
Then it's just a time-barred claim, brackets, that's not an action, but there's no relation back, and because there's no relation back, permission should have been refused because the claim has no prospect of success. That's my point about it's Zedra that needs 35. It needs its claim to come within 35, because unless it does, there's no relation back. It's a be careful what you wish for point, my lords. Because Zedra, in its anxiousness to say, oh, the Vice-Chancellor was right, says Section 35 is inapplicable. But if Zedra's right about that, and we're right about the limitation points, it has a time-barred claim with no route to relation back.
Yeah.
But we say, when one looks at 38, and this is, I quite take my Lord Justice Lewison's point that Satyam may or may not help me, let's get on with arguing it. But because there was no argument on this point, we didn't say, among other things, look at the plain words of Section 38. Of course, an unfair prejudice petition comes within that notably broad definition. So, of course, Section 35 is in play. Brackets, but if it isn't, Zedra's stuffed anyway. I won't keep repeating that. So because Section 35 is in play, one has to look at not only sub 1, but critically for the purposes of this appeal, subsections 3 to 5. So if my lords still have Section 35 open or can return to it, sub 3 sets out the notably limited circumstances in which a court has jurisdiction to allow a new claim within subsection 1b to be made in the course of an existing action. Section 33 is completely irrelevant. It's about personal injury and death. So it's only where rules of the court provide that a claim within 1b can be brought in an existing action. And this is the second be careful what you wish for point that Zedra make. Zedra say, well, 17 doesn't apply, rule 17 doesn't apply, and therefore we're somehow allowed to introduce this time-barred claim. Not so. If CPR 17 doesn't apply, it's common ground that what's referred to in the skeleton arguments of the 2009 rules governing unfair prejudice petitions say nothing at all about introducing time-barred claims, then again, there is no route to introduce a time-barred claim. So contrary to the case they're urging, they need 35 to apply and they need Rule 17 to apply. The problem for them is, if Section 35 applies and if CPR 17 applies, their claim is not permissible as one that's introduced by way of amendment if it is time-barred. And one sees that by reading on. So we were at subsection 3. Subsection 4 just confirms that rules of court may provide for allowing a new claim to which subsection 3 applies to be made. It says only if the conditions specified in subsection 5 below are satisfied.
Yeah. So that limits the power to make rules.
Yes. And subject to any further restrictions the rules may impose. So it's potentially a double limitation. Then one looks at sub 5. In the case of a claim involving a new cause of action, if the new cause of action arises out of the same facts or substantially the same facts as already in issue on any claim previously made in the original action. Absolutely, we challenge the Vice-Chancellor's assertion that unfair prejudice is not a cause of action, because I adopt the definition of cause of action paraphrased by my Lord Justice Arnold. But there is a further reason why an unfair prejudice petition needs to be, or an unfair prejudice complaint needs to be a cause of action for the purpose of the Limitation Act. And that is how broad the definition of action is under the Act. One looks at how broad the definition of action is. So any action in any court comes within section 35(1). And if an unfair prejudice complaint comes within section 35(1), but is not a cause of action, then it can never be introduced by way of amendment. Conversely, if it is a cause of action, it can be introduced by way of amendment if the conditions specified in sub 5A is satisfied. That's the way through, but it's not a way through for the complaint in respect of the July 2016 allotment, because no one is suggesting it is a cause of action that arises out of the same facts or substantially the same facts as those already in issue. The Vice-Chancellor didn't say that. Zedra is not trying to say that. Zedra could not say that on the facts of this case. So it is, in a way, an algorithm or a make-your-own-adventure map where one says, well, is there a route to introducing this by way of amendment? And wherever one forks off along that map, the answer is no, there is no route for Zedra to introduce its complaint by way of amendment. What we say is, with respect to the Vice-Chancellor, he was wrong on Section 35 for the reasons I've already given. And he was wrong to say that CPR 17 did not apply, precisely because CPR 17 at least provides a gateway for unfair prejudice complaints that are out of time to be introduced by way of amendment. If CPR 17 does not apply, then there is no gateway. So, my lords, if you are with us on one of the time limit arguments that we advance, in my respectful submission, it necessarily follows that the appeal on ground 4 is well founded, and that Section 35 and CPR 17.4 do apply.
Can I put a slightly different analysis to you? Section 35 provides for rules of court to permit amendments in certain cases.
Yes.
Rules of court are defined by the Interpretation Act.
Yes.
And they are basically rules made by whoever is the authority for regulating court proceedings in a particular court. Section 413 of the Insolvency Act gives the Lord Chancellor the power to regulate winding up proceedings, and that power is extended to unfair prejudice petitions by section, I think it's 997 of the Companies Act. And it's in pursuance of that extended power that the Lord Chancellor made the 2009 regulations.
Yes.
So they are rules of court.
Absolutely.
If they purport to give the court an unfettered power to allow amendments which don't comply with Section 35, then they are, on the face of it, ultra vires.
Exactly.
But Rule 2.2 says, except insofar as inconsistent with the Act and these rules, the CPR apply to proceedings under Part 30 with any necessary modifications. So one necessary modification is to widen the definition in the CPR of statement of case to include petition.
My lord, yes, quite so. And that is a different route to the same conclusion. But the conclusion is key, obviously, my lord. And the conclusion is you can't have rules of court that override Section 35(5). So you always say, well, is Section 35(5) satisfied? And the answer here is no. And so since it's not satisfied, the introduction by way of amendment is not permissible. Yeah. My lords, unless I can assist you further, those are my submissions on ground 4.
No, thank you very much. Yes, Mr. Chasty.
Lord, what I'd like to do is make some preliminary comments to begin with.
Yeah, let me just clear the decks by putting one of these bundles away. Yes.
Then go on to deal with ground 1, and then probably ground 4, although we've never quite found it easy to understand what ground 4 really adds to the appeal. If I'm down on limitation, ground 4 is probably not going to be of very great relevance, and it really seems to be raised in the appeal because it was an observation that was made by Mr Justice Fancourt. I'll deal with
Well,
grounds
doesn't it
2A.
come out of his grounds for refusing permission, where he seems to suggest it's an independent basis for refusing
Yes,
the
yes,
application?
but my point is, which I'll make, is that if I was to lose on limitation, then whatever I may have to say about ground 4 is not going to save me.
No, but if the judge was wrong on the CPR, we ought to say so.
Well, my lord, I understand that. I understand that. Although, of course, one would rely on the actual definition of statement of case that's contained in CPR, and the whole of CPR 17 is headed statement of
Yes,
case.
well, I've suggested how that might be modified.
I understand. And it may be that there's nothing really further for us to add very much by way of contribution on that. But so after dealing with 1 and to that extent 4, 2A, I'll deal with 2A and 2, perhaps with the hope that I could deal with 3 tomorrow morning. But because as I understand the thrust of my friend's points, although he's not prepared to drop 2A and 2, perhaps he hopes he's keeping them his powder dry for another day. Just by way of preliminary observation in 2A and 2, we've always found it extremely difficult and remain in this difficulty in understanding quite how the case is put on grounds 2 and 2A. So far as the preliminary observations, my lords, are concerned, my friend began by giving you what he said was a brief summary of the fundamental principles of unfair prejudice petitions, and he appears to, in doing so, relied very narrowly on those principles, well-known principles of how people's legal rights might be subject to equitable constraints placed on another party, another shareholder, generally and commonly summarised as quasi-partnerships, a label which obviously sometimes does more harm than good. The actual question is, are the circumstances such as to give rise to equitable constraints, Ibrahimi? But of course that analysis is so far as it goes, if as my friend seemed to do, was to stop there, is a fairly limited and only half the story about the principles of unfair prejudice petitions, because of course, as Lady Justice Andrews in Cherry Hill herself said at paragraph 24, just going back, that's internal page.
Sorry, Mr. Chasey, just before you get into the details of Cherry Hill, can you help me with a very naive question, which is this? Can you explain to me, because I struggle with this, and it's my fault, I'm sure, what's equity got to do with it? Because this is a cause of action, to use that term neutrally for the moment, a claim is perhaps a better way of putting it, a form of claim that didn't exist before the Companies Act 1948. So, what's equity got to do with it?
I'm not going to fight about the point, the implicit that my lord's making there, and it also goes to, I think, the phrase that we've used of equitable compensation. Just to deal with that first, because it's a point that my lord raised. It's quite right that Lord Justice Richards, in the first of the appeals in this case, in this matter, used the word compensation. We've used the word equitable. We've used it in the context, of course, of a claim which arises, we say, as a consequence of breaches of fiduciary duties on the part of the directors.
But I'm not sure that's right.
No, but I'm not going to die in a ditch over trying to retain the use of the word equitable. If the proper approach is to strip that away and say what we're asking for is a statutory, is under the statute, under 996, and the remedies that a court could exercise or the relief that a court could give in its widest sense, which 996 confers, then we're asking for compensation.
Well, I think if we go back to O'Neill and Phillips, Lord Hoffman discusses what unfair means, and you'll remember, no doubt, he says everything's fair in love and war, and it's not fair, it's not cricket, and all these various different ways in which one can use the word fair, depending on context. And in the context of the internal governance of a company, I think all he's saying is that what's unfair may not just be a question of legal rights, but it might be something else.
Yeah.
So all he's doing is, as I understand it, is interpreting the word unfair as it appears in the legislation. He's not creating some sort of equitable structure.
Yeah, and that gave rise to the phrase, which again was then subsequently said not to be a particularly good one, of legitimate expectations in the sense of fairness and so forth.
But to pick up both those points, in fact, I mean, this jurisdiction only came in 1980, and the basis of the allegations of breach of duty in your petition are based in fact upon the statutory enumeration of the duties in the Companies Act.
Yes.
Now, I think the statutory codification says that it's without prejudice to...
You look back at previous common law to assist in interpreting it.
To assist in interpreting, it's always been a bit interesting as to how that is supposed to work. But at least from the codification, I think you're entitled to work on the assumption that these are breaches of duties imposed by statute.
Yeah.
Particularly so in relation to the duty to act fairly as between different groups of members, which, other than macro ipswich, doesn't, I think, ever have appeared in any authority before it was codified. I mean, that's my recollection.
Again, I don't seek to push back on any of that. The only point I was seeking to make by this reference to paragraph 24 of Cherry Hill is just to show the sort of the split of there are two categories, if you like, of unfairly prejudicial conduct that's normally pursued. One is the equitable constraint or quasi-partnership type arrangements, whereby you've been excluded, usually excluded from management is the principal argument. But the point is made at 24 about breaches of fiduciary duties owed to companies. And so at 24, at page 210, the points of the bundle, it says the statutory jurisdiction encompasses two broad categories of complaint. First is a complaint of mismanagement of the company, which can include failures to comply with the constitution and behaviour which would amount to a breach of fiduciary duty or some other actionable wrong to the benefit of the majority at the expense of the minority. The second is a complaint that the majority have been running the company in a manner which, though perfectly lawful, is contrary to the underlying agreement or understanding with the minority. So it's put the other way around there. So the so-called legitimate expectations or quasi-partnership type relationship is the second category. But the allegations based on breaches of fiduciary duty are absolutely full square within an unfair prejudice petition. And that's the point that was being made in the first of the appeals in this case, at paragraph 66. Just to remind my lords of that the point was being made in rejecting the argument that seemed to be made by my friends on that occasion. So this is page 827 at tab 24. At 66, the point was made as regards paragraph 5 that the respondent
just hold on a minute.
I'm sorry, it's at page 842 of the bundle.
24, paragraph 66.
Yes. And this is in relation to some of the arguments as to the prayer for relief. So the respondents submit that as the directors didn't owe Zedra any fiduciary or statutory duties, there's no basis for an award of compensation to be paid by the directors to Zedra. This is not a sustainable argument. Zedra's complaint is of conduct by the directors which was unfairly prejudicial to its interests as a member. The relevant conduct took the form of alleged breaches by the directors of their statutory duties. This formulation of unfair prejudice is entirely in line with the approach adopted in Saul and Harrison and O'Neill and Phillips. It's not dependent on showing fiduciary or statutory duty owed by directors to shareholders. Once unfair prejudice is established, the court has the wide powers to grant relief conferred by 996 as discussed above, and they plainly include the power to order wrongdoing directors to pay compensation to the petitioner. So that's why I take some objection to the proposition that it's the fundamental, when dealing with the fundamental principles. A friend just began by saying, and therefore really unfair prejudice petitions are very much analogous to claims in contract. If you were relying perhaps on the articles alone as your ground of unfairly prejudicial conduct and not pulling the articles, that might have some force. But it's clear that the width of the investigation as to unfairly prejudicial conduct can include breaches of statutory duties owed to the company.
And on that, can I ask another naive question? Because I don't have the depth of experience in this field that my lords have. In a case such as this, whereas Lord Justice David Richards has just pointed out in the extract we've just taken us to, it's a breach of statutory duty. Could a claim not be framed as a breach of statutory duty?
Unfair prejudice petitions usually include claims that there have been breaches of statutory duty.
But my point is, why do you need the statute? Why can you not frame the claim as...
Me as a shareholder? Well, the statutory duties aren't owed to me. They're only owed to the company.
Right.
So I can't bring a direct action as a shareholder.
Duty is only actionable if it's passed for a particular class of person, and the statutory duty is applicable to the company.
The statutory duty is applicable and owed only by the directors to the company. This is why we were in arguments at Hut Group number 1, as it were. It was being argued I was trying to pursue a reflective loss claim of some kind, or I ought to be pursuing as a derivative action. And, well, first of all, of course, we weren't alleging that the company had suffered any loss. But what the Master of the Rolls, what the Court of Appeal in number 1 have done is made it absolutely clear that a petitioner is entitled to rely on breaches of statutory duty owed to the company, even where the company has not itself suffered direct loss, and that 996 combined with 994 creates the widest possible discretion for a court when considering what to do faced with allegations of improper, unfairly and prejudicial conduct. And that's not without significance, of course, when considering, well, is it the case that 994 and 996, notwithstanding that they confer on the judge that breadth of discretion, which is, if one reads number 1 is basically saying it's without limit within reason, nonetheless there is superimposed on that a limitation period, so that you have an inevitably strange position where exactly the same facts in a petition, in an allegation of unfairly prejudicial behaviour, exactly the same facts could, on the friend's arguments, give rise to a right to some remedies, but not others, dependent on when the claim's brought. And the breadth of the remedies has to be considered in that context. We could have a share buyout, and I'm going to come back to that, if I may, in a moment. We could have a share buyout, or we could have a management order whereby the directors are required in the future to manage the affairs of the company in a particular way. We could have a restoration of shares, or if shares are diluted in a way for the benefit of a majority, a court could require shares to be reissued, as it were, recreated in order to create the original proportions that existed. Or we might have, as we do here, a claim for some money. But all of those remedies are open to a judge when he's heard the full trial. And yet, the appellants argue, having gone through that process and found that the relevant conduct amounts to unfairly prejudicial behaviour, his hands are tied now, and that the discretion which is conferred on him by 996 is actually not as wide as everybody thinks, because it has superimposed upon it limitation issues.
No, I think Mr. Ashworth comes at it from the other side.
Well, I understand that.
He says you
I-
don't get as far as a
I understand
trial.
that, but the consequences that still have to be thought through as to where they go, because one also has, and these are. My friend makes the point Section 8 applies or Section 9 applies, but there's no actual analysis about where that conclusion actually could go in the outside world dealing with these petitions, and what the repercussions could be and so forth.
Can I just try and ground this a little bit? Section 994 sets out a series of requirements for it to apply. It applies where there's been unfairly prejudicial conduct to the affairs of the company.
Yeah.
As my lord said to you, going back to O'Neill and Phillips, Lord Hoffman essentially interpreted the meaning of unfair prejudice in the statutory provision. And he said you have to have a frame of reference. It's not, you can't just say everything's not fair in love and war, it's not cricket, you sit under a particular palm tree. But what he said is, and this is the paragraph that's always quoted, where after he said that the company is an association of people closely monitored, which has developed seamlessly from the law of partnership and the like, he says that those features have carried over into company law. And then he said, the first of these two features leads to the conclusion that a member of a company will not ordinarily be entitled to complain of unfairness unless there has been some breach of the terms on which he agreed that the affairs of this company should be conducted. Just pause there. That's this case. The second is there may be cases in which equitable considerations make it unfair for those conducting the affairs of the company to rely upon strict legal powers. That's sometimes badged quasi-partnership.
Yeah.
But just returning to the first, because that's this case, why is it wrong to suggest that in essence it's like a breach of contract claim? The contract is the Articles of Association as reinforced by the shareholders' agreement, if there is a shareholders' agreement, and overlaid by the statutory duties which are imposed on people who hold office as directors in accordance with the articles. Why is it wrong to start from the assumption that a claim of this type looks more like a claim in contract than anything else?
Well, there's no contract. I suppose the simple answer is there's no agreement between me and the directors.
Yes,
there's an assumption.
There is. There most definitely is.
Well, there's an assumption.
No, there most definitely is a contract because the Companies Act provides that the Articles of Association have the force of a contract.
Oh, of course, I accept that within the context of the articles. But where one is talking about breaches of statutory duty, for example, there's merely an assumption on the part of the shareholder that directors will comply with their obligations.
Well, no, you provide in the agreement, which is the Articles of Association, for how people are to be appointed directors, and when they are appointed, they are subject by statute to certain powers. So there's an express agreement that people who are appointed under the articles as directors must comply with their statutory duties.
Well, I would say there's an assumption that they would do that, but a minority shareholder is not going to be able to play any role, to just use that point, in the appointment of the directors. The directors will be appointed by the majority, and then the minority will assume that those directors will do what they're expected to do.
All the shareholders agree that those who are appointed as directors in accordance with the articles will be subject to the statutory duties which the law now imposes on directors.
Yes, what I'm concerned about is the assumption that they will conform and comply with those obligations. But I don't have a direct claim against them for their actions.
A shareholder can, in certain circumstances, take steps to enforce the articles by contract. I mean, you can, for example, a shareholder can bring a claim for a declaration that a resolution passed
Oh, I see.
is
Yes.
invalid, for example.
Yes.
I mean, that's
But-
not
but-
a 994 claim.
But I don't. But my lord, we seem to be talking about the analogy position now, and I don't know if my
Yeah, well,
lord's got in
it-
mind the ground 2A and sections 2 and 5. which
No,
I'll
I thought it was
come
because
back to.
you wanted, as the start of your submissions, to take fairly fundamental issue with the way that it was put in opening, namely that
My lord.
essentially 994 is in this type of case where there's no allegation of quasi partnership. This is a quoted company. That in essence it looks more like contract than any other species of.
Well, I have a statutory, to use the phrase, cause of action. I have
Yes.
no other cause of action. I have no other right of breach of contract or anything of that kind to bring against a director who's behaving wrongly, whether that's in direct breach of the articles or in breach of his statutory duties. I have a sui generis 994 ground for relief and platform for relief. That's all I have.
That I'm entirely happy with as a proposition. So maybe that's
Maybe that's as far as
we need to go. Okay.
Well, the other preliminary point I wanted to make is my friend says, well, it's okay, you can park buyout orders in Section 8, but any order for payment of money is in Section 9. And we just, with respect, question whether it's quite as simple as that, and why is a buyout order simply parked into Section 8 if say it doesn't, but if Section 9 were to apply? Because when a party asks for a buyout order, they're asking for money. They don't bring the claim for a buyout order because they want to unburden themselves of onerous shares which they don't want to have the responsibility of keeping. They bring a claim for an order for a buyout on the basis that they want to bring the relationship with the company and the other shareholders to a complete end. And what they're asking for is money. And it's even more significant. And the reason I stress this is because it just is to stress the potential impact of the argument that the Limitation Act applies. It can't just be said in our submission answer to that, well, it is different. It's a buyout. It's a transaction where something is being exchanged for something else. Because, of course, it goes further, as was recognised in Cherry Hill. A petitioner may often ask that the price at which their shares are bought out are not the value that they reflect at the time of the transaction. So if, for example, an order was made, you buy the shares and that transaction goes through, they may say, well, the value of my shares is less now than it was several years ago because of the things that I've been complaining about as regards unfairly prejudicial behaviour. And as was noted in Cherry Hill, I'll take you to remind my lords of it in a moment, the court will say, in its wide discretion, we'll order that the majority buy out the shares and that they buy at the value that the shares would have had, but for the wrongdoings. Now, query with respect, why isn't that an order for the payment of money? Because the shares at the time of the relevant order might be worthless or have a very low value, but the price that's paid for them might be very significant. And again, it would have to be thought through, as it were. How does it, what if the relevant, to use a simplistic rather vulgar phrase, what if the hand's in the till that you're concerned about in order to put the money back in for the valuation? What if that occurred 8 years ago or 12 years ago? And how does it work, this assessment, with the impact of the Limitation Act is what I raise. So the idea that it's convenient from a friend to say, well, everything's a specialty and therefore everything's Section 8. So you've got 12 years, but the payment of money is 6 and a buyout is not a payment of money. That is to cushion, it might be thought, the impact of finding that the Limitation Act applies. And if the Limitation Act were to apply to buyout orders, that would obviously, if it does, it does, but that would send huge shockwaves around the company law world, as it were, practitioners, to say that you can't bring a claim for the most basic remedy, the normal remedy, outside of a 6-year period.
On this hypothesis, it's a 12-year one. And why is a 12-year limitation period so shocking?
Well, I don't have to fight to save a 12-year limitation on the facts of this case. If it's a specialty, but it's not Section 9, if it's Section 8, then
You're
the
in
appeal
time.
fails.
Yeah.
Because 2016. So you may feel you don't want to hear very much from me about that.
No,
my
you're
point
absolutely right.
was,
It doesn't matter on the facts of this case,
No.
but it matters to the analysis for the reason I was suggesting to Mr. Ashworth, which is if it is the case that a statutory claim, and this is a statutory claim as you've already accepted, is an action on a specialty, then prima facie Section 8 does apply, subject to any question of whether you're then within the exception that takes you to Section 9. And the point about that is that it does tend to suggest that the idea that there's no applicable limitation period is a myth.
to the extent that Section 8 applies, yes. To the extent that Section 8 applies. My point was merely to stress the potential impact, as it were, of finding that this case falls within Section 9, because if this case falls within Section 9, I just raised, as it were, the rhetorical question, on what logical basis doesn't an order for a buyout fall in Section 9?
Well,
And that would be very serious.
Suppose that it does. Suppose that it does. And what sparks off the claim for a buyout is a one-off event, as happened here. Is it so terrible that you've got to bring your claim within 6 years?
Well,
If it's a course of conduct, then it may be a case where it's the last straw that breaks the camel's back, in which case you bring your claim when the last straw has been loaded onto the camel, or within 6 years after the last straw has been loaded on the camel.
in order to answer that, if I'm going to go into the policy considerations, as it were, is it so terrible that a Section 6, a 6-year period under Section 9 should apply? If the policy of the Limitation Act is to stop claims which are very old, clogging up the courts and time, and I can't remember what the phrase was, taxpayers' money being used on very old claims, then we still have this problem, as I identified before, that under 994, under 996, there is no limit to the range of remedies that are going to be granted. And so you're not going to stop, if the policy is to stop the courts being clogged up, as it were, with 994s, you're not going to stop that, because people will still bring claims. They might, I don't know how far one would be able to do this, but one can imagine this might be a reaction. You wouldn't commit to the type of relief that you wanted in your prayer. You just ask for an order under 996 for whatever relief the court thinks fit. And that would then include the potential, at least, of remedies being awarded which are not money payments. And there would be all sorts of battles if somebody tried to strike that out in some way at some kind of interim stage, and arguing that you had to commit yourself to a particular remedy. Because there is this range. If these shareholders, if these directors had held shares and the company was not a PLC now, if it was a company of the type that more commonly comes before, a court might order, rather than the payment of equitable compensation, there's a giving up of their shares in that form of compensation, as it were, compensation in kind, in order to remedy that wrong. But all the same facts are going to give rise to those positions.
I suppose what you'd say is that there are oddities. I mean, if, for example, you have a minority shareholder who has been wronged in the conventional way, if I can put it that way, usually they say, I want to be bought out. But if that would be to trigger a limitation period, they will always just simply say, I actually want to buy the majority out.
That's what I was just going to say.
Because then that wouldn't, on the face of it, fall foul of the Limitation Act, because that will be a claim to pay money.
Exactly.
in return for shares. So every minority shareholder will simply say, I want to buy out the majority or such other relief as the court thinks fit, and then, hey presto, they're apparently immune from the Limitation Act.
And these results just don't seem logical or behind the policy of the Limitation Act, that you start to play games with the relief that you're seeking in order to get your trial. Because, of course, more often than not, 994 petitions are issued and they don't fight, but because people don't want to see a trial. But you would craft your remedy in a way that would overcome
part
those.
of the difficulty with that, Mr. Chasty, is that, as I was saying to Mr. Ashworth at the beginning of his submissions, the Limitation Act is an odd mix of limitation periods that apply to particular classes of causes of action and limitation periods which apply to the seeking of particular remedies. And so sometimes what's important is the legal basis for coming to court at all, and sometimes what's important is what are you asking the court to do.
I'll have to look at when we come to section 8 and 9 to see which of those areas 8 and 9 fall into.
Yeah, I mean, limitation for contract says founded on contract or founded on tort.
Yeah.
So you look at the cause of action for that.
But
Section 36, for instance, which is the analogy section, talks about claims for specific performance, injunctions or other equitable relief. It doesn't tell you what the underlying cause of action is.
And 994 just creates a platform for the court to consider, is the behaviour of the respondent such as to give rise to unfairly prejudicial conduct, but that 996 doesn't want to have any specific entitlement to any relief. I have no entitlement to relief beyond the exercise of the court's discretion as to what that relief should be. I have no entitlement to recover a sum of money. I'm going to, obviously, I'm slightly thinking ahead about section 9. I don't have a right under 996 to recover a sum of money.
Yeah, I mean, most of your arguments, pretty much all of your arguments for fairly obvious reasons, are directed at section 9.
Yeah.
To pick up the Lord's point, I mean, section 8 is drafted in terms of the cause of action rather than the remedy.
But section...
And
sorry, Lord.
Because it's an action on a specialty, which people seem to accept, includes an action brought pursuant to statute.
The way that it's defined...
So there wouldn't be any encouragement for people to game the system if that were the applicable limitation.
If it was 12 years.
If it's 12, I think your point about people gaming the system with their relief and the inconsistencies or oddities comes from as was pointed out, from the way in which section 9 is structured.
That's right, it does. I understand that it would be less... It'd be more difficult to play the game if it was section 8 than it is if it's section 9 that applied. I'll come on to section 8, obviously, in due course. Of course, 994 doesn't create any obligation. 994 itself, to just link to section 8 for a moment, 994 doesn't create any obligation or duty on anybody.
Creates a power in the court.
Exactly, that's all it does. It doesn't confer on me any entitlement as such to relief, unless I establish to the court's satisfaction there's unfairly prejudicial conduct. But it's not creating an actionable claim against an individual in itself. It's enabling me to present a series of facts to the court and asking the court in the exercise of its power to remedy in some way.
But why isn't that a cause of action within the definition that Lord Justice Arnold pointed out in the Tang and Cooper?
Well, it is, except to the extent it then requires the additional link, or the addition to the link, as it were, the determination of the unfairly prejudicial conduct by the court, which is a bit like the Smith argument that we'll come back to. The other point that I was going to make, just in terms of where does this go, is a slightly more general point, which is that you wouldn't, as a shareholder, normally bring a claim for winding up of a company on the grounds of just and equitable under the Insolvency Act. if you had an alternative remedy. And the alternative remedy is normally, of course, the fact that you can go by way of unfairly prejudicial conduct petitions. If I'm mainly raising this just to suggest what might happen as a result of it being found Limitation Act applies. If a party were to understand that they were barred by the Limitation Act from bringing an unfairly prejudicial conduct claim because they're statute barred, then if they brought a claim for just an equitable winding up, which I don't think it would be said is subject to any specific limitation Act period.
Why isn't that within Section 8?
Well, I don't understand it's ever been suggested. This is opening up.
We're in a new world.
Exactly, new world. As my Lord Justice Lewison said, my friends are asking you to effectively overturn, or at least rewrite, at least probably 40 years of understanding of the legal position as regards unfair prejudice petitions.
Sometimes it takes a little boy to point out that the emperor has no clothes.
So, of course, my lord, but he needs to understand what the consequences of that might be. But he's not insignificant.
In the story, he was right, wasn't he?
It cannot be insignificant. Look, it cannot be insignificant, and it has to be taken into account in our submission. That there is not one authority, not one sentence anywhere, in authorities, in textbooks, in the law commissions, in any kind of journal or reasoning, to support the proposition that is being advanced on behalf of the appellants. What is being said is that everybody, the law commissions, one of which was the chairperson was Lady Arden, the observations of Lord Leggett in Smith, the observations, they're going to come on to ground one, of course, the observations of Malort and Lady Justice Andrews in Cherry Hill. All the leading textbooks, Palmer, Joffe, Hollington, everybody has missed the point that actually a fundamental problem exists, and that is that unfair prejudice petitions are caught by the Limitation Act. And it is a relevant factor.
Well, I think it must follow from the logic, just to pick up the point you made a few moments ago, that just and equitable winding up petitions would also be caught.
I'd probably want to. I was mainly just thinking about the repercussions of it, but that probably logically would follow.
Well, I mean, they would, on the face of the argument that's put, they would definitely be caught by Section 8. Because they're...
If Section 8 applies here, yes.
Yes, well, I mean, I asked rhetorically, what would the difference between a 994 petition and a just and equitable winding up on this basis? As far as Section 8 is concerned.
If it's an entitlement to a remedy created by a statute, then Section 122 of the Insolvency Act is doing that. If logically Section 8 applies to unfair prejudice petitions.
But and then I suppose the only other development of that theme is if you're seeking a just and equitable winding up on the basis that you have to allege the company is solvent and you would be entitled to a dividend in the winding up. Is that in fact a claim for recovery of money? I'm just...
You're doing it in order to get your distribution.
I'm following through the logic that you've introduced.
But you're doing it in order to get... You're bringing your just and equitable, apart from the mischief, no doubt, and trying to force a situation to resolve matters by agreement. You're bringing your claim on the basis that the company has to be solvent.
Well, you have to allege the company's solvent, and you would be entitled to distribution in the winding up.
And that's on the face of it what you're doing it for. You're doing it to get the company wound up, its assets to be sold off and its assets liquidated and realised, and then you'll get, after payment of all the appropriate debts or whatever, you get your distribution. So you are to that extent pursuing it for money.
Right, but your point is nobody has found an authority in which anybody suggested that just and equitable winding up proceedings are subject to limitation.
just in the same way that, despite all the best efforts of my friends, they've not found a single authority that suggests a 994 is. And indeed, just going through it, my lords have already got the points. We do have several first instance authorities where, I know my friend went through 6 or 7 where he said limitation didn't arise, but we do have Edwardian, an extremely detailed analysis of the law of 994 petitions and the consequences of delay. We had Grand Actual, where Mr. Justice Ratty commented on the point. We do have the Allied case, which my friend referenced, which was in the Court of Appeal, where there was an 8-year delay on a buyout, and no suggestion was made at all of the Limitation Act having anything to do with the analysis or the exercise. We've got 2 Law Commission reports saying the same thing. One specifically dealing with limitation, and the other dealing with company matters, including 994s.
And both citing an authority which doesn't support the proposition.
By citing DR Chemicals, yes, but having done so on a full consultation on the basis that nobody was able to come up at the time, I assume, with anything better than explaining the proper approach to take, which was its latencies and acquiescence. And then the additional point which was made is that the Law Commission, having recommended that unfair prejudice petitions should be caught by limitation, when the opportunity came to make that clear, everybody, as it were, across the legal community being told by the Law Commissions there is no relevant period, the 2006 Act simply comes and goes with no addition. Can I go, my lords, to ground 1? Because our case, of course, is that this matter can be dealt with quite quickly, and if
You say we're bound by Cherry Hill and that's the end of it.
as simple and as straightforward as that, my lord, yes. So far as Cherry Hill is concerned, just to go to this again, if you go, it's page 204 in the bundle. Sorry, I'm slow on tabs. It's tab 7. The point that I made earlier about the remedies that was going to be sought, it's paragraph 20. Originally, the claim that was first struck out was something of a mess. It was fairly common ground as it had been formulated. At paragraph 20, the relief that was sought says his shares in the company have been rendered worthless. He seeks an order that his shares in the company should be converted to a 49% shareholding in the third respondent, a company belonging to Norma and Jenna, and those shares be bought from him. He also claims various direct payments by way of compensation. And then 21, there are obvious problems with such relief, and at the hearing of the appeal, Ms. Tithcott frankly and fairly accepted if the appeal were allowed, the petition would need to be radically overhauled. She stated that in place of all the relief currently sought, Andrew would have to seek an order for his minority shareholding to be bought out on valuation assumptions, which would notionally build in the value of any monies, assets or profits that were found to have been wrongly extracted or diverted from the company. And then 22, given Ms. Tithcott's confirmation that Andrew was no longer seeking any direct payment to him of monies, which would be due to the company in restitution, damages or equitable compensation for misfeasance, the points made in the respondent's notice and points by Mr. Gilchrist about reflective loss no longer arose. So that recognises that this flexible approach to the price at which shares are purchased is something that it was acknowledged was going to be taken advantage of. And then going straight to paragraph 36, the heading is not without significance. The correct approach to delay in this context. There is no statutory period of limitation applicable to unfair prejudice petitions. Just pausing there. That is not said as it is common ground, there is no statutory period of limitation, or it is unnecessary to consider whether there is a statutory period of limitation because, or a reservation of any position by Lady Justice Andrews when she said that. It directly follows the general question about how an approach should be taken to delay. And no doubt, perhaps it might be said, that that clear, unequivocal first sentence is based on the 40 years of legal understanding that existed in relation to unfair prejudice petitions.
Isn't the more likely explanation is it comes straight out of Edwardian?
Well, and if it does...
which was common ground between the parties.
It was, yes, well, and I'll develop that if I may, because Edwardian is clearly considered in this case, and it is endorsed as being correct, and it's approved, and that includes the judge's rejection, for example, of whether or not the Limitation Act applied by analogy, because that was one of the arguments that was advanced to him in Edwardian. So when it says it was common ground before us that where there's been delay, the correct approach is that adopted by Mr. Justice Fancourt, what was common ground, at least as it's being described there, is that the approach adopted by Mr. Justice Fancourt was the right one to follow when you're considering acquiescence and delay. But the first sentence is without any ambiguity whatsoever. And in our respectful submission, there's a degree of, my friends, conflating two separate points here. What is the ratio? And how can you not follow a ratio once it's accepted that that is the position? And they are two separate points. But it must follow absolutely clearly in our submission without any real source for uncertainty or debate almost, that the ratio of this case includes that statement there, that there is no statutory period of limitation. If that statement is wrong, that's a different matter. But if it's
can you help me on this? Imagine that one took a red line through that sentence, blue pencil, whatever other metaphor you care to adopt. Just imagine that sentence is excised from this judgment. It has, what impact in your submission does that have on any of the reasoning that follows?
Well, it's then, if you take that line, if you take that sentence out and you go then straight to considering the correct approach to delay in this context as solely being acquiescence and delay, then you do so on the premise.
That's not what you, with respect.
The Limitation Act.
With respect, that's not what you're being asked. At least I don't think it is. If you take the first sentence out, the judgment reads, it was common ground before us that where there has been delay in the issue of a petition, the correct approach is that which was adopted by Mr. Justice Fancourt in Edwardian Group. And then that is set out. And in the third line of that sentence, it says, there is no statutory time limit for issuing a petition. That is part of the correct approach where there has been delay in the issue of a petition. The point is being made is that you would still arrive at the same result because it's just effectively lifted from the third line of the quote from Mr. Justice Fancourt.
But it's being considered. I'm moving on to the slightly separate point probably about myself now, about how do you avoid following a ratio if there is one. But clearly Edwardian is being considered in that first sentence. It's not being, it's particularly referred to. And whether it's right or wrong, it's clearly being taken as authority for that proposition that's expressed in that first sentence.
Yeah. But that's a different point than the one I think you were making. You were saying, forget everything that comes after the first sentence of paragraph 36. Just look at the first sentence of paragraph 36. There, we're done.
Well, maybe I was overstretching my point. But what is quite clear from Kadim is that this court would have reached an entirely different decision if the Limitation Act had applied. And so that's paragraph 17, and you pose the negative for the purposes of Kadim in order to arrive at the ratio. It's an unequivocal statement. If it's wrong, it's still binding. But that's a separate point. But the whole of the decision flows from the proposition that no statutory period of limitation applies. And that isn't said to be on the basis of any concession. That is a clear assertion from Lady Justice Andrews herself as to what the legal position is.
Well, except it's common ground. I mean, if it's ratio, that's one question. The second question is, if it is ratio, is there an exception?
Yes, quite. And that's I'll come on to that in a second. I'll come on to that.
You're, I think, just dealing with the first point.
I am, that's right. But I just want to look at 36 and these other paragraphs. I'm not going to read them all out, but I'll just make the points as I'm going through them. So you can see that having made that clear, unequivocal statement in the first sentence, there is then a reference to Edwardian. Edwardian is quoted with approval, which includes the sentence, there is no statutory time limit for issuing a petition. And then there's a reference to delay. In Edwardian itself, the judge was presented with the argument that the Limitation Act should apply by analogy, and he rejected it and dealt with the question of how to approach the delay by reference, as it were, to late cheese. And then over the page at 214, it says, to similar effect, Mr. Justice Peter Gibson in Re-Amended Company held that the test was whether the delay renders it inequitable for the petitioner to be allowed to obtain relief. That, again, in our submission, is an endorsement or an approval that is the proper approach to be taken to the question, what is the correct approach to delay?
Doesn't that just emphasise that it's got nothing to do with limitation?
No, no, it's because it's adopting that general reference to, you consider whether the delay makes the question of relief inequitable, not is there an automatic guillotine or shutter that comes down anyway.
You're still on, is this ratio?
I'm still on, is this ratio? And all that I'm seeking to point out is that there is this considered view that is identified. There's this consideration of the views expressed previously, which you can see lends support to that first sentence of paragraph 36. Then what you have is a detailed review and analysis of Mr. Justice Fancourt's own approach. And this is 37, 38, 39, 40 and so forth. And then there's the more, if you like, there's the further refinement. There's a further explanation about how to approach the question of delay at 46. It seems to me where delay is concerned, there's a distinction to be drawn between a shareholder who knows he's been excluded from active involvement and fails to complain about that for many years, and a passive shareholder who knows that he's getting the company accounts or an invitation to the AGM and is not receiving dividends. None of that is consistent with a Limitation Act just bringing the shutter down. It's all consistent with the Limitation Act not applying, and that wouldn't have happened if it had been thought the Limitation Act applied. So we say the ratio is clear, and there's just no wriggle room in our submission in terms of what the ratio is for the appellants. So the appellants are then forced to try to avoid that by saying that this is one of those exceptions. We're not, of course, in what you might say are the normal areas. We don't have a some other Court of Appeal case where it's inconsistent with this one, or a Supreme Court case which is to the contrary. We're in this Kadim exception. For what it's worth, one might have thought that the actual decision to allow the appeal was surprising, but nonetheless, that's not really terribly important. What is important?
Sorry, in Cherry Hill.
Sorry, no, in Kadim, the actual decision, once you got to the end and allowed it, was surprising. But that's by the by. Could I come on to Kadim, my lords? So this is page 959.
Tab?
Tab 30. There is a long process of analysis of authorities to get to the view expressed, it seems, with some hesitation rather, at paragraph 33, which is page 969, where it said, "We therefore conclude, not without some hesitation, that there is a principle stated in general terms that a subsequent court is not bound by a proposition of law assumed by an earlier court that was not the subject of argument before, or consideration by that court. Since there is no direct Court of Appeal authority to that general effect, we should indicate why we think the principle can be justified. 34. First, even though it's assumed on the basis of some observations in Davis and Johnson, the categories in Young and Bristol Aeroplane are closed, National Enterprise establishes that isn't so in respect of the present line of authority. Second, in each of the authorities cited, the rule is in fact stated in general terms, even though the facts addressed may be in narrow compass. Third, we have to remember that it's the reasons that bind and not the decision. Any formulation of a rule of precedent must be flexible enough to respect that basic truth. This is what led Lord Diplock to say in Baker and Queen, that while an assumed proposition may be part of the ratio, it doesn't have a precedential value. To hold otherwise would come close to permitting the outcome of a case to dictate its status. Fourth, it's recognised a court can identify a part of the ratio that's not been the subject of an argument and deny it precedential value. But then 38 is really extremely important. Like all exceptions to and modification of the strict rule of precedent, this rule must only be applied in the most obvious of cases and limited with great care. The basis of it is that the proposition in question must have been assumed and not have been the subject of decision. That condition will almost always only be fulfilled when the point has not been expressly raised before the court and there has been no argument on it. And there may, of course, be cases, perhaps many cases, where a point has not been the subject of argument, but scrutiny of the judgment indicates that the court's acceptance of the point went beyond mere assumption. Very little is likely to be required to draw that latter conclusion, because a later court will start from the proposition, encouraged by judicial comity, that its predecessor did indeed address all the matters essential for its decision. And we say, first of all, obviously, great care must be taken to justify departing from the ratio in Cherry Hill. And it will take a very clear and obvious case to justify that. Cherry Hill, we say, is not such a case. And again, to use the words in 38, scrutiny of the judgment we submit indicates that the acceptance of the point went beyond mere assumption.
So where does one find in Cherry Hill any discussion of sections 8 and 9 of the Limitation Act, and what constitutes a specialty, and Farmiser, which was, of course, decision of this court?
We don't.
Where is any of that?
We don't.
Any intimation whatsoever that it was anywhere near the court's mind?
We don't, because it wasn't necessary to do so, because for right or wrong, the view was taken, the considered view was taken, that the Limitation Act had no application, and that included sections 8 and 9. So there was no necessity to address a point that it was felt didn't arise. I feel as if I'm telling my lords what my lords have studied, but my answer to that is that
isn't the clue in the paragraph we'd seen from Cherry Hill that the parties adopted a common position, that the approach that they wanted the court to apply was that set out by Mr. Justice Fancourt in
Edwardian.
in Edwardian. So there was simply no argument on the Limitation Act at all, because the parties agreed that was not the starting point, or indeed the end point.
there was no argument. My lords were there. I wasn't there. I take it that there was no argument, and the judgment hasn't missed that. There was no argument, but the absence of an argument in itself isn't the basis on which to say you don't have to follow the ratio. The point made in Kadim is, going back to the words again, is it just an assumption? Well, I respectfully submit that Lady Justice Andrews' analysis, with which my lords agreed, went beyond mere assumption, that made that statement that the Limitation Act did not apply on a considered basis.
Yeah.
And merely because she doesn't set out, there's no authority to the contrary, there's several court of first instance cases, the Law Commission, etc., doesn't mean that it wasn't considered. She doesn't say it is common ground that the statutory period of limitation doesn't apply, and that I also
think
and
that's
I understand
very close textual analysis, given that, as my Lord Justice Snowden says, the same sentence appears in the passage about which there was common ground.
Well, yes, but it's taken and it's adopted as her own.
Yes. Well, if you assume a proposition of law is correct, you then analyse the facts on that basis. That's what you do.
Yes, but I say that she did so by reference to Edwardian, which itself expressly refers. She doesn't express any disagreement or any doubt about that. There is no statutory time limit for issuing a petition. She expresses no concern or hesitation about that general statement. And while she doesn't say it, I would very much hesitate to suggest that Lady Justice Andrews, as with respect like my lords, would not have been aware of the general understanding for the last 40 years about what the law was in respect of limitation. And as I say, if my lords got it wrong, that's one thing, but that's not for here. I'm not remotely suggesting my lords got it wrong, because they got it absolutely right. But it would be, it's very ambitious for my friend to say, all, if I may say, my lords and Lady Justice Andrews just made an assumption without any consideration of the point.
Although looking at Kadim, I mean, the way that this is all introduced, this use of the expression assumption.
Is this in Kadim?
Yes, in Kadim, sorry. It really sort of starts at paragraph 20 through to 24, I suppose, but it talks about a line of authority for the proposition that a ratio or part thereof is not binding if it was assumed to be correct without the benefit of argument without the benefit of argument to that effect. So, I mean, is the exception if the court makes an assumption that a proposition of law is correct without the benefit of argument to that effect. That's the exception, is it?
Well, the exception's put at 33 again. There is a principle that a court is not bound by a proposition assumed by an earlier court that was not the subject of argument or consideration by that court. The words there are or consideration, so there might not have been argument, but the court might have considered the position itself, and that's what I say has happened in Cherry Hill. It hasn't just proceeded on a common position from the parties and not itself effectively endorse that position, is what I'm saying. It's not, for example, it all goes back.
So if there's no argument and the court gives no consideration to the point, but moves on to consider the other point, then this exception kicks in.
Well, 33 seems to open that possibility, but then in the same breath, 38 says it's going to be a very rare case.
But rare cases happen.
Rare cases happen, but they've got to be clear and obvious rare cases. And in our submission, this isn't one of them, and it says at 38 that...
well, the clear and obvious relates to not to the proposition itself. Clear and obvious relates to the question about whether there was argument or consideration.
Yeah. I think that's right, yes. But the point again is made at 38. Scrutiny of the judgment indicates the court's acceptance went beyond mere assumption, and very little is required to draw that conclusion. Certainly the law reporters at the All England Law Reports thought that they were drawing a ratio out of Cherry Hill, for what it's worth. It might not be worth much, but again, it's indicative of how somebody else...
But this current argument is based upon the proposition it is ratio, but can you depart from it?
Yeah, quite. Yeah, sorry. Quite. I should have... just going back to my Lord's reference to 20, you can see some examples of where the exceptions might arise, or how it might be discovered. I think that there's just been assumption. So, for example, 22, a proposition may be the subject of agreement or concession between the parties. The court, in acting on it, may or may not specifically reserve the issue of whether it's lending its own authority to the correctness of that proposition. And what we submit is, you were in Cherry Hill in our submission in that first sentence, lending your authority to the correctness of the proposition. First, well, expressly stated by Mr. Justice Fancourt in that first sentence of paragraph 36. You were lending your authority to that statement. And in our respectful submission, anybody fairly reading that, anybody fairly scrutinising that decision, would conclude that that's precisely what you were doing. I should have just briefly, while we're still in ground one, there's a checklist provided in Young Sam. So this is tab 31 and paragraph 59. Just so far as this checklist, just because this has been identified by my friend, just to go through that checklist. Paragraph 59, so the various considerations. 1, the degree of unanimity or consensus among the judges. Well, it was unanimous. 2, the clarity or otherwise of the ruling. The first sentence couldn't be clearer. Whether or to what extent the point on which the court ruled was in dispute and or the subject of argument. Well, we've covered all of those points. I accept that there was no argument, but clearly it forms the basis of the decision, in that if it had been thought by this court that the Limitation Act did apply, then things would have been very different. Whether or how clearly the court evinced an intention to establish a binding rule, I say you did very clearly in paragraph 36. Whether and to what extent prior relevant authorities were considered, well, they were considered. 6, whether the court would or sensibly could have reached the same result if it had not ruled as it did. No, it couldn't. 7, whether the court's ruling had been applied or approved in later cases. We do have the overture observations, but nonetheless of the Supreme Court, which I'll just look at briefly in a second. Whether the ruling or its underlying reasoning has been criticised by commentators, to which my friend said, not yet. There's not been, I don't know if he's aware, maybe he's writing something, I don't know, but there's not been anything for 40 years to criticise the proposition that the Limitation Act doesn't apply. Whether the court considered or contemplated the factual situation that's arisen in the current case, no, you didn't consider directly a claim for compensation of the kind that we're advancing, but you did clearly consider the possibility of a share purchase buyout at this recalculated value, as it were, and the level of the court in the hierarchy of the court. That's obvious. Just in terms of Smith on this point.
Just to be clear, that's not ratio either, is it? I think somebody made that point earlier.
Yeah. And yes.
As you can see most clearly from Lord Justice Haddon Cave at paragraph 39, which is quite trenchant on the subject.
It's a checklist that my friend referred to, but I think I get at least 9 or 10 out of 11, which are more positively in my favour. And then just in terms of completing the point, in Smith and RBS at tab 34 at page 1066. The regime under sections 140 of the 1974 Act is not unique in treating the consequence of delay in bringing proceedings as a matter governed partly or even wholly by an exercise of judicial discretion rather than a statutory time limit. There's some types of claims which are not subject to any statutory period of limitation at all. One example is a claim for specific performance, where the only control for delay is the discretion to refuse relief by late cheese. Another is a petition for relief under 994 on the ground of unfair prejudice. Where there's been delay in issuing such a petition, the court's approach is to consider how the delay should affect the exercise of the discretion under 996 to make such orders the court thinks fit. If in view of the delay and the reasons for the delay it's unfair in all the circumstances for the petitioners to obtain the relief they seek, the court will exercise its discretion to refuse it. Cherry Hill approving Edwardian. So Lord Legate, forgive me, is of the view that in Cherry Hill, in taking those paragraphs that you did from Edwardian, which includes clearly the sentence, there is no statutory time limit, we're approving those observations in Edwardian. Clearly, one might think that if Lord Legate was asked, did you confer authority of this court to that proposition of law, he we would submit, have said, yes, that is the conclusion that he drew. And this.
I mean, actually, I don't know whether you did, and I'm sorry if I didn't pick it up, but I mean, the real force of your point in this respect, I think, comes from the fourth line of paragraph 58, doesn't it? Because he introduces these two references by saying there are some types of claim which are not subject to any statutory period of limitation at all.
Yeah.
So
he's certainly adding his weight to the proposition.
What weight does it have when there's no discussion whatsoever of Section 8 and Section 9?
Well, merely because it doesn't consider Section 8 and Section 9 expressly, doesn't matter in my submission. It's a general observation.
In Smith, it was common ground that Section 9 did apply.
Yes.
But the issue was, when did the limitation period start to run?
Yes. Well, it's an overture observation.
Yeah.
But it's of it's a pretty impressive weight, if I may say, in terms of him lending his observations and authority and saying clearly his analysis of what you did in Cherry Hill was to make that conclusion and add authority to that proposition, and that you did so by approving Edwardian. And so I'm merely making the point that if in fact the Limitation Act does apply, then the understanding of Lord Legate, with whom there was unanimous agreement, including Lord Briggs in respect to, I mention this because of more specific experience of unfair prejudice petitions, agreed 1053. So it's heavyweight support, even if it's overture support for the points that we're seeking to make.
Now, if you go back to the legislation, I mean, he doesn't quote it all, and I haven't personally looked it up. But,
Sorry, my lord, we're in Smith.
It's Smith, yes.
Yeah.
So go back to paragraph 12, page 1055 of our fund. He introduces sections 140A to C. 140A says that the court can make an order under B if it determines the relationship between the creditor and the debtor is unfair. And then B1, he says at paragraph 14, sets out a list of things which an order may do, gives the court a wide range of powers. The key provision for present purposes is B1A, whereby an order may require the creditor to repay, in whole or part, any sum paid by the debtor. Now, I haven't looked up to see what else the court can do under that section, but the way that Lord Legate is approaching it is he looks at the particular remedy which is being sought, namely an order for repayment under section 140B. That, he says, or he seems to accept, at paragraph 31, that is the applicable limitation period. So you'll have to entitled to say, well, that was common ground in that case too. So, but the point is, he doesn't say, oh well, this is all terribly wide. This is such a wide variety of powers that the court's got that this particular claim can't be within section 9.
No, I will, if I may, just look at this overnight.
Yeah.
But so far as this is our point, I want to develop this more fully tomorrow. It's an important point, obviously, section 9. But one of our principal points, of course, is that section 9 is dealing with an act that expressly provides for the payment of money, and states that that is what it's doing by that act. Whether you call that a contribution or whether you call it an adjustment for West Riding. But where the Act specifically refers to a payment of money, that's very different in our submission from 996. I don't think I can add anything further to ground 1.
Right.
So far as
Then we were going to ground 4, I think.
I don't think there's very much more I need to say about ground 4 from what I said earlier. Really, ground 4 just simply doesn't arise, or apart from the fact my lord may feel that it's appropriate to make certain observations, as my lord.
Well, I mean, do you say the judge was right in what he said?
He was right to say that CPR 17 refers to statements of case.
Yes.
And the definition of statement of case does not include petitions. And the mere fact that an order may be made to require a party to serve a points of claim, which is not uncommon in an unfair prejudice, does not convert that petition or points of claim to a particulars of claim for the purposes of constituting a statement of case as defined.
But if CPR 17 doesn't apply, either in its own terms or because you make a necessary modification under the 2009 rules, then where is the power to allow you to advance a new claim?
Under the unfair prejudice rules, which allow the court to...
Well, how can they?
Well,
But wouldn't they be
if I'm
out-
statute barred,
They'll-
and the point
they'll
I'm...
be out travaris, wouldn't they?
No,
If they purport to give the court the power to allow an amendment, bringing in a new claim where that new claim does not satisfy the conditions in section 35, they'd be out travaris, wouldn't they?
Yes, if I'm limitation, this is why I'm not sure there's very much in ground 4. If I'm limitation barred, I'm limitation
Yeah,
barred.
but that's why I'm asking you,
Yeah.
are you supporting what the judge said? Because, I mean, if people go away with the impression that whether or not there's a limitation period,
Well,
the court's got a completely free hand.
I'm supporting the reasoning that he gave in terms of his analysis of what CPR 17 actually does say. And to the extent that my lord feels that that needs to be construed in a different way, that is not a point that I'd understood was being taken as such by the
All right.
my lords, I'm not sure what time my lords have in mind.
4:15 usually.
Yes.
How are we doing for time?
Well,
You've got
quite well, I think.
2A,
2A,
2 and 3.
yes. I'm going to spend most of my time on 3. So
Yeah.
I'd like to do that in the morning, start in the morning.
Yeah.
Just in the 2 minutes I've got, just in terms of 2A and 2, just dealing with 2 first of all. With respect, we've never, and I don't think our view has changed, really understood
This is
reliance
section
on
21.
Section 21.
Yeah.
Section 21 started, if I can put it that way, with the appellants. It was the appellants that said Section 21 apply, and they said this in their skeleton pretty clearly at paragraph 32. They said for the purposes of 21, a director of a company is a trustee and is entitled to rely on 21(3) as a defence, unless 21B or A apply, and they relied on first sub C, and they said they'll wait and see what's argued. And then at 36, they said that in order to circumvent limitation, we were attempting to bring 994 an action in respect of a breach of trust. The appellants against whom the complaint is directed are entitled to rely on 21(3), they said. Indeed, the Vice-Chancellor recognised the scope but rejected it. Then, I'm not going to go into this in detail, but just to explain how then the argument seemed to become very, very stretched. So we said, well, if you're relying on 21(3), we can rely on 21(1)A, the fraud exception, and that's our respondent's notice, to which then their response to that seemed to be to backtrack somewhat from their assertion that the director was a trustee, or at least of the Class 1 type trustee within Paragon, to then try to say that in some way Section 21(1)A didn't apply.
Yeah, they're advancing the Schrodinger's cat argument.
It's very, very difficult to follow, and it becomes extremely artificial. The starting point is very, very simple, and that is, in our submission, 21 does not apply. The director, the beneficiary in this scenario that's being relied on is the company, not me. And it's an extraordinary feat of legal alchemy to try to, in some way, create a 21(3) defence by speculating as to what might have happened if the company had suffered loss and had wanted in some way to bring a claim against the directors. The simple fact is, as noted in the whole basis of the rejection of the reflective loss argument in this case number 1, is the company has not suffered any loss. We've not asserted that the company suffered any loss. The short point is, in our submission, that 21 has no application. Directly, and most certainly not by analogy, which becomes extremely difficult to follow. And so we had this extraordinary line. So they start by saying the director's a trustee and they can rely on 21(3). We then said in which case we rely on the bad faith exception. We must, if 21(3) applies, they can't have it both ways. They can't say 21(3) applies, but you can't rely on 21(1)A. That would be absurd. So it doesn't apply. They argued it was a Class 1, Paragon Class 1 type trustee. They now seem to want to say, well, it might be a class 2, so 21 doesn't apply. We've set it out in writing,
Yeah.
the laws, as to why we say 2 and 2A just have no substance to them. I'm not, unless you wanted me to go into that any further, I'm not sure I can add
No,
very
fine.
much to what we said in writing. I'll come on, if I may, in the morning to section 9.
Yeah. You might like to have a look, both of you, on ground 1 at the FHSC and GLAS, GLAS case that I mentioned, which is Lord Justice Leggett yet again on the question of when a Court of Appeal is bound to follow a previous case.
Thank you, Maud.
10:30 tomorrow.
Court rise in England.